Hi, I'm Johnny, and my friend Alicia and I are here walking you through the helpful information you can find at oklahomadisasterlegalhelp.org. Sometimes a natural disaster strikes, and you or your family reach your financial breaking point. You may be faced with the decision of whether or not to file bankruptcy. How do you know if you need to file? What even is bankruptcy, and how does it work? Let's share some helpful information with our friends, Alicia.
Simply put, federal bankruptcy laws provide help for individuals and businesses who owe more debt than they can pay. Bankruptcy laws allow for either a fresh start through the liquidation of assets or by creating a payment plan to repay creditors in an orderly manner. You should know that bankruptcy is only one method of resolution of a debtor's financial difficulties. Non-bankruptcy workouts may be a better alternative and can provide an acceptable resolution for individuals, businesses, and their creditors. There also may be circumstances that arise where a potential debtor should not file bankruptcy and risk a denial of discharge, while giving up non-exempt property for liquidation and distribution to creditors by the trustee. You can choose the kind of bankruptcy that best meets your needs as long as you meet certain qualifications. Of course, this is general information and is not intended to be legal advice. You should consult an attorney for more detailed information regarding your specific situation.
Bankruptcy is a scary word for most people, so it helps to understand what steps are part of the process. When someone wants to file for bankruptcy, the individual must complete credit counseling at least 180 days before filing for bankruptcy and must provide your pay stubs for the 60 days leading up to your bankruptcy filing. Bankruptcy begins when a petition is filed in the bankruptcy court by an individual, as a couple, corporation, or some other type of entity. When filing a petition, the debtor must file a statement listing assets, income, liabilities, the names and addresses of all creditors, along with how much is owed. Once this is done, this will prevent debt collection actions, like lawsuits or wage garnishments, from proceeding. Their creditors will be notified once the petition is filed. What happens next depends on the type of bankruptcy that is being filed.
Yes, good point, Johnny. We need to talk through the different types of bankruptcy the laws allow. First, a Chapter 7 bankruptcy is called liquidation. A debtor must be under income maximums to be eligible for this type of bankruptcy. If a debtor's income is over the eligible amount, then they must file a Chapter 13 bankruptcy. A trustee will be taking control of all the debtor's assets and then liquidate those assets, meaning they will turn them into cash. The cash will then be used to pay off creditors who have secured claims. You should know that certain property you own is exempt from being liquidated. If there are no assets to liquidate, that is called a no asset case. Creditors who have unsecured claims will only get payment if the case is an asset case, and then only if the creditor files proof of claim with the court. When a bankruptcy court discharges an individual's debt, that individual is no longer required to pay off that debt. Once the petition is filed, the whole process can take a few months to get the discharge.
Next up is a Chapter 12 bankruptcy, also called an adjustment of debts for a family farmer or fisherman with regular annual income. If an Oklahoma family farmer with regular income is struggling to pay off their debts, they can typically file for this type of bankruptcy and propose a plan to pay back any debts over a maximum period of 5 years. A trustee will be appointed to make sure the creditors are paid back as planned. This type of bankruptcy allows a family farmer to continue their business operations while this payback plan is going on.
And lastly is a Chapter 13 bankruptcy, also called an adjustment of debts of an individual with regular income. People tend to favor a Chapter 13 bankruptcy rather than a Chapter 7 bankruptcy because a Chapter 13 bankruptcy allows a debtor to keep their property that a Chapter 7 bankruptcy would liquidate. A Chapter 13 bankruptcy allows a debtor to create a plan to pay back the creditor over a time frame of usually 3 to 5 years. There will be a hearing where the court will approve or reject the debtor's repayment plan. The court will appoint a trustee, as a middleman, to make payments to creditors based on the individual's expected income. While Chapter 7 bankruptcy will discharge the debt of the individual, a Chapter 13 bankruptcy does not. The individual will still have to pay the debt, although some of the debt is eliminated. While the plan is in effect, the individual cannot be sued or have his wages garnished by creditors.
Woo! That's a lot of information. And you might be wondering about which debts specifically can be discharged and which debts cannot. For each chapter of bankruptcy, there are different debts that are discharged. Section 523 of the Bankruptcy Code is the best source to determine which debts are and are not discharged for that bankruptcy. Debts typically not discharged might be student loans, late child support, or alimony payments, damages for willful and malicious injuries to person or property, debts gained from fraud, and government-imposed fines or penalties. But again, you should look at the code provisions for the type of bankruptcy you wish to file for a complete list. Also, you should seek out a bankruptcy attorney to help you with the process.
Okay, so let's say you're considering filing for bankruptcy. The most important thing you can do is talk to an attorney. However, there are some things you can do on your own to plan for bankruptcy. 1. Stop using any credit cards you may have. It is a good idea to avoid using your credit cards for at least 90 days before you file for bankruptcy. If you continue to use your credit cards with the intention of filing bankruptcy, you may not be able to discharge the debt, and you could be charged with fraud. 2. Stop paying unsecured debts. It may be difficult to do, but you should not pay any bills that are unsecured if you are seriously considering bankruptcy. That means do not pay credit card bills, medical bills, signature loans, or any other debts that are not secured with collateral. Student loans, however, are not dischargeable, and you should continue to pay them if you can do so without taking money from your basic living expenses. Your first priority should be to pay your mortgage, car payment, utility bills, and grocery expenses. If you are behind on your mortgage payment, try to work with the creditor to catch it up. Take the money you would be spending on your credit card payments and put it towards your house payment.
3. Keep paying or catch up on debts that you want to keep. When you file for bankruptcy, you must list every debt that you have, even those that you would like to keep. Most people want to keep their secured debts, like a home or a car. If you want to keep a debt after filing for bankruptcy, you will need to sign a reaffirmation agreement with the creditor. A reaffirmation agreement is a signed agreement that will be filed in your bankruptcy case, which tells the court that you and your creditor agree that the debt will not be discharged and you get to keep the collateral as long as you continue to make payments. Most creditors require that your payments be current before they will agree to provide you with the reaffirmation agreement. You will need to think carefully about the debts that you may want to keep. High interest secured debts, like for furniture, are not good debts to reaffirm on. If you choose not to keep a secured debt, you will have to return the secured item to the creditor. For example, if you have a loan for a Kirby vacuum cleaner, that loan is secured by the vacuum cleaner, and if you decide you do not want to pay, you will have to give the creditor the vacuum cleaner. If you are going to file for a bankruptcy, and if you have a secured debt that you do not want to keep, you probably should discontinue paying that debt. the creditor may repossess the property or ask you to return it. However, you can seek discharge of the debt in bankruptcy. 4. Student loans. Student loans are usually non-dischargeable in a bankruptcy. So if it is difficult for you to pay them, the best solution is to try and work out an income-sensitive payment plan with the loan holder. If that is not possible, you may be able to seek a hardship exemption. They are very hard to get, and you may need the assistance of an attorney to get one. Usually, only individuals who have become disabled are able to successfully obtain a hardship exemption.